Ready, start. The tribunal has failed to notice and made perfunctory passing reference while dealing with the issue of limitation. Full stop. Tribunal has failed to consider and no finding recorded that the petitioner was pursuing remedy before civil court mala fide or good faith. Full stop. The above statutory provision contemplates continuation of delay and tribunal was under statutory obligation to consider this aspect of double inverted comma sufficient cause double inverted comma clause warranting condonation when statute provide for single inverted comma limitation single inverted comma clause full stop. As observed by the tribunal, there is no question of single inverted comma latches, single inverted comma clause, like the writ proceedings under Article 226, comma Constitution of India, full stop. The question is of single inverted comma limitation, single inverted comma clause, and jurisdiction for condonation in law, full stop. In view of the above, comma, it was statutory obligation on the part of the tribunal to have considered as to whether petitioner had sufficient cause for not making the application within limitation period under section 21 within bracket 1 of the act full stop. Not having done so, the tribunal has failed to exercise jurisdiction vested in law and its finding to that extent cannot be sustained and liable to be set aside full stop. In the instant case, comma, the petitioner was acting in good faith, comma, diligently and bona fide through to pursue his remedy apparently with no ulterior motive or any malice on his part, semicolon, particularly when there is nothing contrary to show in the pleadings or the evidence of the respondents, full stop. The period consumed in prosecuting his remedy before alternative forum, semicolon, namely, comma, civil court is liable to be excluded, full stop. We have no hesitation to hold that petitioner is not guilty of delay or laches at all, full stop. The period spent during 10/4/1996 till dismissal of second appeal on 2/8/2004 is liable to be excluded on the ground that there is, comma, on the record, comma, sufficient cause to explain the delay, full stop. In that event, comma, original application cannot be said to be time barred and it could not be dismissed on the ground of limitation, full stop. As far as second ground available to the petitioner for seeking regularization under departmental scheme is concerned, comma, we find petitioner has been throughout claiming right of reinstatement under certain scheme and for that department were required to consider his claim in consonance to a direction given by Supreme Court in the light of direction in the case of Miss Usha Kumari Anand within bracket Supra full stop. The tribunal has not applied its mind to the terms and conditions as well as requirement under relevant circular slash scheme dealing with reinstatement. Full stop. Tribunal has passed a cryptic order in this respect. Full stop. In view of the above, comma, we are not in agreement with the judgment and order dated 15/12/2004 passed by the Central Administrative Tribunal, comma, Allahabad is hereby set aside. Full stop. Considering delay in the matter, comma, is bound to prove fatal the interest of justice, requiring that departmental order dated 10/4/1996 passed by respondent number 3 on the basis of its ex parte finding that working certificate was semicolon false semicolon close and was issued without giving adequate opportunity to the petitioner, comma, is set aside and we further direct the concerned authority to decide the matter afresh on the basis of the record before it. full stop.